Court is now in session. My name is MIWashington, and I'm the judge that will be presiding over this session. Everyone should please make sure that their devices are muted until their cases are called. And then once the attorneys place their appearances on the record, please state your name. The court will call a case of the State of Michigan versus Willie Caldwell, case number 23 FD 1456.
David Jan on behalf of Willie Caldwell, who is incarcerated.
Mr. Caldwell, please get them to unmute your device for you, sir.
Yeah, there we are.
Please state your name, sir.
Yeah, my name is Willie Ralph Caldwell.
Thank you.
You're welcome.
All right, we're here for sentencing today. There's been an updated report. Did you have an opportunity to review that court report with your client, Mr. Shand?
Yes, I did.
Any additions, deletions, or corrections?
It is factually correct, and we think the recommendation is very fair.
All right. Ms. McDuff?
Your Honor, I agree. It's disheartening to know that Mr. Caldwell had just completed a treatment and then tested positive for two substances, I believe, alcohol and cocaine, days later. But I saw him get arraigned on that warrant, and he repeatedly said he needs more treatment, and I agree. So whatever's available to him to receive, I hope that he gets that. That's all from people.
Thank you. Anything else, Mr. Shand, before I go to your client?
Yeah, I will work from my end to see. I think he's going to need 90 days inpatient residential treatment. I'd love to get him into Don Farm. I've got two people that in the Don Farm jail program that can help in that way as well. So we'll see what we can do. I do know that his parole agent has a parole hold on him as well. So I will, I'll talk to Ms. Bennett and see if she can go along with the recommendation from the court that if he is released to inpatient residential treatment, that she'll release the parole hold, because unless that's released, he can't go. So, but I think it's exactly right, and I think Rachel's exactly right, and I thought the recommendation was really good. Yeah, I get it. I mean, if anybody, I get it. I mean, my last child custody hearing with my second ex-wife, the only issue was my drinking, and I showed up to court at 8:30 in the morning and I was drunk. So I get it.
Gotcha. Mr. Caldwell, good morning,
Yes.
sir. What would you like to say?
Good morning. What do you say?
What would you like to say, sir?
I mean, there's no excuse. I had death in the family, and I agree with everything that's been recommended. I need to go to treatment, and I need to be associated in a recovering community, like maybe something like sober living, continuing on. And I want to get my life together. I'm upsetting my family, and I totally agree.
Well, Mr. Caldwell, I think that one of the important things this morning is recognizing it yourself. And it sounds like you are there at least. And it's a disease. You need help with it. Accept the help and work really hard, because every day you're going to have to do that. You got to commit to it every day. So I'm going to follow the recommendation. It is the sentence of the court that you serve 365 days in Washtenaw County Jail. Credit for the 27 you've served. The 338 days need to be served. You need to complete a new substance use assessment, and then if you are approved, you can be released to an inpatient treatment program with a GPS tether. Okay?
Yes.
All right. Good luck to you, sir.
Yeah. Thank you.
You're welcome.
And thank you, Annette. You did a great job. That was a really fair recommendation.
And I will send an email to Ms. Bennett to let her know what was the sentence today as well.
Thank
Perfect.
you.
Thank you.
Have a good day, Mr. Shan.
Thank you. You have a good day, Judge Washington.
Thank you,
Thank you, Your
Mr.
Honor.
Cole.
Can
Yes, you may be, you can go now. You can let them know you're done.
okay then, thank you.
Thank you.
Yeah.
State of Michigan versus Latanya Smith, case number 22FB 1375.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Latanya Smith. Ms. Smith, can you state, oh, she's getting unmuted.
I'm gonna unmute her. She just got up. She'll be back. You're unmuted now. Please state your name.
Thank you. Yeah. Good morning, Latanya Smith.
Good morning, Ms. Smith. All right. We're here on a violation of bond, violation of bond. I think the last bond violation that we were referring to was from February 11th of 2024, when there was a reading of 0.028, and then apparently on March 1st, they considered you having absconded from the sober link, but I know that as of March 8th, at least, you were in home and new vision. But it's the interim time period that we did not receive testing. I believe that the magistrate arraigned you on that back on March 12th. Is that correct, Ms. Smith?
Yes.
All right, thank you. Ms. White, where are we now with this? What would you like to do? I know she is in residential again, home and division.
That is correct. As to the not testing, Ms. Smith does want to admit that she was not testing, did not test during that period. Is that correct, Ms. Smith?
Yes.
And
What
Your
about-
Honor, I'm so
Yes.
sorry. I see that we last saw Ms. Smith on January the 31st, and she was arraigned at all the violations at that point. So we have, I think, at least two positives. I think that might also include the February 3rd, in addition to the 11th and the,
Oh, February 30th then?
yes.
I think she's been seen since then.
We saw her on February 5th. She only admitted to January 16th, is what my notes indicated.
Yeah, we didn't have that report yet.
Whoa. She only admitted to January 16th. Actually, my notes must not be right because I don't even see a January 16th in here. Oh, that's the date of the, wait a second. That's the report date, January 16th. Not the event date. Let me find that report date. All right, so January 16th report took us through events on January the 12th. So she admitted through everything through January the 12th, which meant that she hasn't reported, she hasn't admitted to January the 20th or February 3rd or February 11th, and then just the failing to test after that. So that is really what she needs to plead to or have a hearing on. So on January 12th, ma'am, it indicates you had a BAC of 0.047, and then you kept testing until it reached 0.013. I don't see it ever really going back to. No, I said she did the 12th. It's the 20th. Okay, so on January 20th, excuse me, this is what you're being alleged to have violated. January 20th, a BAC of 0.041, and you didn't retest, and then you didn't retest, and then you got down to a 0.015. And then I'm going to skip over the January 23rd and January 30th stuff. She didn't test at all those days. Well, she didn't test on January 30th at all. But I'm going to request that there be an admission to the February 3rd BAC of 0.102, and then we got down to a 0.039. That's as low as we get on that date. And then February 11th, a 0.028, and then she got down to a 0.016. And then she just failed to test. Beginning on February 22nd. From then on, she just stopped testing. So out of all of those, what is she planning to admit to, Ms. White? Or do you need more time to talk to her?
Ms. Smith, are you admitting to those violations, or do you want to talk to me some more? She's shaking her head yes. Is that yes, you're admitting to those violations?
Yes, but the ones from the February, because
you have to say yes or no, or you and I can go into a breakout room and talk.
We can go in the breakout room.
What's this matter? The court will call the matters of, I'm not sure how to pronounce it, MIWashington, case numbers 24T00038, as well as 24S, which is a state case 00072. So we have a township and a state.
Returning deputy for the people.
Paul Barnett on behalf of the township.
Good morning, Your Honor. Alexander Hermanovsky for Amasio McIntyre in both matters. Your Honor, this is time and date set for pretrial in both matters. I was appointed on both of these cases on Friday. I still have yet to receive discovery on the township case, and I've started discussions with Ms. McDuffie about how the case is going to go forward, whether we can have a resolution or not. We're asking for an adjournment in this matter. There is a pending felony case. I believe the PE is tomorrow, so I'm asking for the next available pre-trial date in this case. I was going to ask to address bond, but I learned that PR bond is on both of these matters in this case, so the felony case is what's keeping them at the county jail.
Mr. Amazio Taylor, please state your name.
Amazio McIntyre.
I'm sorry. That would be better than what I just called you. Yes, sorry about that. Any objection to the adjournment?
No objection.
Not from the township.
All right. You say the P is tomorrow? Is that the PE or the PCC?
I believe it's the PE.
Okay. So you would one, I mean, I could put it over to March 25th or April 1st. Which one? March 25th or April 1st. Which one works best?
March 25th. I don't know what's going to happen tomorrow, but if it's possible to get them out of there sooner rather than later, I want to keep that as a possibility.
All right, thank you. Pre-trials adjourned to March 25th, 2024 at 9 a.m. Bond is continued.
Thank you, Your Honor.
Corrected as a PR bond. We'll see you then, sir. If you happen to get out before then, you need to show up here on Zoom or show up in person, okay?
Okay.
Thank you.
Have a blessed day.
You too.
Thank you, everyone. Have a good day.
State of Michigan versus. One moment. State of Michigan versus Romella McIntyre, case number 23 FB 1537. State case, as well as another state case, 24S00052.
Richmond, Deputy for People.
Good morning, Your Honor. Good morning, Your Honor. Edward Drukas on behalf of Romello McIntyre on the 1537 matter.
Thank you. Good morning, Mr. Drukas.
Good
morning, Your Honor. Mr. Drukas, Mr. McIntyre, Assistant Public Defender Davi Lebo before Mr. McIntyre on the 5-2 matter.
Good morning, Mr. Lebo. Mr. McIntyre, could you state your name for us, please, sir?
Romello McIntyre.
Thank you, sir.
Welcome.
All right, we're here for retrials. Make sure it's in both cases. Oh, this one's so long.
And
Yeah.
Mr. Lebo, I know you just had a breakout room. I don't know if there was you had a direction on the case. We were looking on setting our matter for a settlement conference.
My intention was to see if any pleas would be on offer prior to considering a final settlement conference.
Yes, Mr. Lebo reached out about a potential resolution for his case. I let him know that since Mr. McIntyre had 2 cases on the docket, that I should probably speak with both of them offline about whether there is any sort of resolution that would involve both of those. So Mr. Drukas, I'll defer to you on how you want to move forward with that.
Understanding if you decide to set it for a final settlement conference, then no offers are on the table.
With that, I do know that they are separate offenses. I don't know what kind of global resolution could potentially be had. I understand. I've seen the police report. I don't believe that the complaining witnesses are the same. I don't know what potential offer there may be. Mr. Romello, would you like to adjourn the case and try and seek another resolution, or set this matter for a trial where there would be no offers in the case?
Can we adjourn the case?
Okay. If we could ask for a brief adjournment, Your Honor.
I'm pretty much wide open. Any Monday.
2 weeks would be April 1st.
That sounds great.
Sounds like a plan.
Retrial adjourned to 4/1/2024 at 9 a.m. Bond is continued on both cases. We'll see you then, okay? Mr.
Okay.
Romello?
Yes, Your
Thank you, Your Honor.
Thank you, Your Honor.
State of Michigan versus John Tavis Hayes, case number 23S00438.
Richmond Deputy for the People.
Assistant Public Defender Allison Mueller here on behalf of John Tavis Hayes. Mr. Hayes, can you unmute and state your name for the record, please?
My name is John Tavis Hayes.
Good morning, sir. All right, we're here for pretrial today.
Yes, Your Honor. Mr. Hayes does want to plead to the charge. He wants to plead as charged. My understanding is that the offer from Ms. McDuffie would be a sentencing agreement to no upfront jail and not to authorize a charge that could have been authorized with this charge. Is that correct, Ms. McDuffie?
That's correct. It looks like there was a maluse of telecoms charge that was apparently overlooked when this was originally authorized by the APA who reviewed the warrant. So my agreement was for those two things. And Ms. Mueller, I just want to confirm your answer to my question I asked you in the email is
Yes, I was going to address that too. Your second concern for Mr. Hayes, I believe, is not a concern at this time. He does have anything that would cause that to be a concern under control and can move forward with the plea today.
okay. We can approach really quickly, Your Honor, because I know you're looking at us like, what the heck are we talking about?
Okay, please approach. All right, we're back on the record in the matter of the state of Michigan versus John Tavis Hayes. Mr. Hayes, are you still here? There you are, sir. If you could unmute and Did you hear the offer that was placed on the record were for you to plead as charged, and in exchange, there would be no further charge coming for malicious use of telecommunications services, and there would be an agreement, prosecutor, a sentencing agreement for no upfront jail. Do you understand that, sir?
Yes.
And is that what you want to do?
Yes.
So malicious destruction of personal property, 200 or more, but less than 1,000, is what the original charge is that you would be pleading to. That is a misdemeanor carrying a maximum penalty of up to 1 year and or $2,000 fine plus court costs. Do you understand that, sir?
Yes.
All right, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
You may lower your hand. I'm going to go over some rights that you have that you're going to like. Stop me if you have any questions or if you feel like you need to speak with your attorney again, okay?
Okay.
You have the right to have a trial by a jury, at which time you can call witnesses to speak for you. You can get an order signed by this court to require those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you, and you have the right to be a witness for yourself, or you could choose to remain silent. If you chose to remain silent, the prosecutor could not comment on that. In addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand all those rights, sir?
Yes.
Understand you're going to be giving up all those rights and you're not going to be having a trial of any sort?
Yes.
Do you also understand that there's no automatic right to appeal this decision? So that means in all likelihood, this decision is going to stick with you?
Yes.
And do you also understand that if you're on probation, parole, or bond on the date of this offense, which was July 2nd of 2023, and you still are on that same probation, parole, or bond today, that you could be in violation of it by pleading guilty?
Yes.
And were you on probation, parole, or bond on July 2nd of 2023?
No. It was after.
Afterwards, okay. And then finally, if you're not a U.S. citizen, you have immigration consequences. Are you a U.S. citizen, sir?
Yes.
Okay, good. To the charge of malicious destruction of personal property, 200 or more, but less than 1,000, how do you plead?
Guilty.
Anyone promise you anything other than what we placed on the record to get you to plead guilty?
No.
Threatening you in any way, shape, or form?
Huh?
Is anyone threatening you in any way, shape, or form?
Oh, no.
Okay. So let's turn to the date of offense. Between July 2nd of 2023 and July 5th of 2023, were you at the vicinity of 8817 Lagoon Drive?
Yes.
And while you were there, you maliciously destroy someone's tires?
Yes.
All right, Miss Brianna Campbell, what you do, puncture the tires?
Yes.
I find that there's a factual basis for the plea that's been willingly and knowingly. Well, let me, one more thing. The value of those tires, do you stipulate that it was more than $200, counselors?
I do, Your Honor.
Yes, the people also stipulate as well.
I find that there's a factual basis for the plea that's been willingly and knowingly made. Are you satisfied, Ms. McDuffie?
People are satisfied, Your Honor.
Ms. Mueller?
Your Honor, the defense is satisfied as well.
Thank you. Sentencing in this case will be on April 15th, 2024 at 10 o'clock a.m. Sir, I'm going to give you a phone number and I'm going to give it to everyone else at the same time that might need to reach out to the probation department. So while he's getting a pen, you should get a pen too. Make sure you have the number ready, a pen ready.
Pardon me 1 second.
All right. Don't see anybody else getting a pen.
I'm ready. When you're ready.
734-483-7336.
Okay.
You're all set, sir. Please call them tomorrow after 9 o'clock a.m. to schedule an opportunity to have your PSI done. You'll need to set up a conference. I think they do it via Zoom or Teams or one of those so that you can be interviewed, and we'll have a report by the time you come back here. Please have that done before you return, okay?
Right.
Thank you. Have a good day, sir.
All right, sir.
We'll call the case of Ypsilanti Township versus Gianni Ketzner, case number 23T00768.
Paul Barnett on behalf of the township.
Assistant Public Defender Allison Miller here on behalf of Gianni Ketzner. Mr. Ketzner, can you unmute and state your name for the record, please?
Gianni Alexander Ketzner.
Thank you. Good morning, Mr. Ketzner.
Good morning.
All right, we're here for a pretrial today.
Yes, Your Honor, we'd like to set this matter for a final settlement conference.
Thank you. Final settlement conference in this case will be on April 25th, 2024 at 11 a.m. with a jury selection on May 3rd, 2024 at 8:30 a.m. If there's nothing further, bond will continue.
Thank you.
You're welcome. Have a good day, sir.
You too. That was April 25th, right?
Yeah, your next one, which is going to be on Zoom, is on April the 25th.
All right. Thank you, guys. Have a good day.
You too. Recalling the matter of the state of Michigan versus Tva9mi7jc, case number 22FB1375.
Rachel McDuffie for people.
Assistant Public Defender Sandra White on behalf of Latanya Smith.
Thank you.
This is Latanya Smith.
Thank you, Ms. Smith. All right, Ms. White, where are we with this, please?
She would like to admit to the violations with explanation.
Thank you. Ms. Smith, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may lower your hand.
Can you repeat that?
I said you can lower your hand. That's all I said so far. All right, Ms. Smith, it's my understanding that you're going to admit to the violation from the positive test on January the 20th, February 3rd, and then just you stopped testing. Oh, February 11th, and then you stopped testing. Is that correct?
Yes, ma'am.
All right. I find that there's a factual basis for the plea has been willingly and knowingly made. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
Yes, satisfied, Your Honor.
All right. So where do we go from here? I guess is the question.
Well, Your Honor, as to the not testing, Ms. Smith lost her backpack, which contained the SoberLink and other personal belongings. She did try to report it to the police, but they told her that she would have to come in personally, and she wasn't able to do that. She did report it to probation that she did lose the SoberLink. As for the positive testing, she did check herself into home of New Vision. I know part of the recommendation was to check herself, maybe do transitional housing, which she can't afford with her current rent. She does ask the court to allow her to continue to test with the SoberLink if she gets out, and to allow her to do continue outpatient treatment after home and New Vision. She has changed her therapist to a trauma therapist and changed sponsors. She wants the court to know she is the only caregiver for her daughter. At the moment, school counselors are helping to care for her daughter. And she is on a new course of treatment with home and New Vision.
Ms. McDuffie.
I don't know what I mean, I'm not equipped to know what Ms. Smith needs, but I'm almost afraid for her at this point because she's been in and out of treatment. She was, I understand Ms. White just said that she has some new things. She has a new course of treatment, a new sponsor, a different therapist. But I don't know what's going on with her. All these other factors around her are changing, and I hope that a breakthrough is imminent because these violations go back so far. to, you know, almost a full year ago. Looking at last May or so, positive alcohol tests, just last summer, last May, June. I just don't know what the disconnect is, where something's not getting through, because there hasn't even really been a pause. I don't know that we've had even a solid window of some sort of sobriety for maybe a few months or so. So I'm just really worried about Ms. Smith. I don't know if she's been assessed recently and if outpatient is still where she is in terms of what she needs, but I hope that she
she's in home and new vision inpatient right now.
Oh, she's an inpatient now. Okay, good. So yeah, I mean, I defer to the court, but I am really afraid for Ms. Smith at this point.
I think my concern is I don't think she fully understands the magnitude of the problem right now. You know, not being able to afford transitional housing compared to where she's going to be is not understanding the magnitude of the problem. Ms. McDuffie is correct. We've had so many violations, I can't even keep track of them. I do not see how she can do anything other than be in transitional housing at this point. I mean, we're still at the let's see, what stage are we at? We're at the VOPs. I just don't see how we get around transitional housing. So I think you need to continue to talk to your client and come back with a plan for how she's going to make that work.
Her problem, I'm sorry, go ahead.
She can do transitional housing or she can spend some time in jail.
Can we adjourn so that maybe Ms. Smith can look into that?
Yes, definitely.
Okay.
I'll bring you back here. I think, let's see, she's supposed to get out.
It's April 4th is her last day for residential, Your Honor.
Okay, I'll see her on April 1st. April 1st, 2024 at 10 o'clock a.m. And hopefully we have a plan by then, because the reality is I don't trust, and I don't really think 30 days is long enough for her, but that's not my area of expertise. Only so far as recovery court has taught me some lessons, and this does not appear to be the route or the place that she should be at this time, based on my past experiences, but I'm not an assessor. I'll see her back there on April 1st. As far as the bond is concerned, I will do I'm gonna set it as like a $5,000 release to inpatient treatment type of a bond. So she needs to remain in inpatient.
Would Your Honor consider a new assessment?
Of course, you can present me with whatever you would like to present me with for your argument. I'll see you back here on April 1st, ma'am.
Thank you.
Thank you. State of Michigan versus Victor Frost, case number 23-00355.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Victor Frost. Mr. Frost, can you state your name for the record?
Victor Harold Frost.
Thank you. Good morning, Mr. Frost.
Good morning, Your Honor.
All right, we're here for a pretrial in this case.
I'm sorry.
Yes, Your Honor. Mr. Frost wishes to plead guilty to the charge. I believe the only offer from the prosecutor was no upfront jail.
That's correct. Oh, Your Honor, may we quickly approach the probation before we proceed?
May. They need to break up.
No, they're in person.
They're on the Zoom.
I'm sorry, who?
Me and Ms. McDuffie and probation and Ms. White. What's your name with the iPhone?
You're asking me? Oh, I'm sorry, I thought you were asking me.
First name Gerard, last name Calhoun.
Thank you, sir.
You're welcome.
Fortunate that you.
All right, we're back on the record in the case of the state of Michigan versus Victor Frost. Mr. Frost, it's my understanding that you're going to be pleading guilty as charged to the charge of domestic violence. That is a misdemeanor. It carries a maximum penalty of up to 93 days and or up to $500 fine plus court costs. Do you understand that, sir?
Yes, I do.
Understanding that, sir, is that what you want to do? Plead guilty as charged with
I was told that I could. I'm sorry, I can't afford that. I can't afford that. I only have $215 on my card right now, and I only make $1,006 on a month.
Sir, as far
I'm
as
sorry.
the potential penalty and the fines and costs, you can set up a payment plan, but maybe you need to speak with your attorney so you can
Set
fully
up-
understand what's going on.
I'll send up a payment plan.
Okay.
I didn't understand that I had that option.
Okay. So you are gonna plead guilty today? You'd be pleading guilty to a criminal charge.
Yes,
You
I
understand?
plead guilty.
All right, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide, sir, will be the truth, the whole truth, and nothing but the truth?
Yes, yes, Your Honor.
Thank you. You may lower your hand. All right, I'm gonna go over some rights that you have that you're gonna be giving up, okay?
Yes.
All right, thank you. Right to have a trial by a jury, sir.
All right, can I say something? My legs are in serious pain and I can't sit like this for a long time. I have neuropathy, severe neuropathy, and it's really bad. I'm sorry.
Do you need to stand while I go over your rights with you?
I have to be in a lay down position, and just, you could continue, please. I'll try to bear.
Right. You have the right to have a trial by a jury, at which time you can call witnesses to speak for you. You can get an order signed by this court to require those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you, and you have the right to be a witness for yourself, or you could choose to remain silent. If you did choose to remain silent, the prosecutor could not comment on that. And in addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand all those rights, sir?
Does that mean I have to go to trial?
No, it means that if you want to go to trial, those are the rights that you have to
Trial.
and no, but do you understand you have those rights?
Yes, I do.
And you
I'm sorry,
understand
I'm not smart as cookie on the block.
that's okay, but you understand you're going to be giving up all those rights and
Yes,
you're
I
not gonna be having a trial?
Yes.
All right. And there's no automatic right to appeal this decision. So the decision you're making today, in all likelihood, is going to stick with you. Do you understand?
Yes, I do.
And do you also understand that if you were on probation, parole, or bond on May 19th, 2023, this could be a violation of that. Were you on those? Any of those?
And what you're talking about.
Were you on probation, parole, or bond, sir?
If I am on it or
were you on May 19th, sir?
No.
Okay, all right.
I'm
And that's
I
okay.
Very well, because I don't hear well out of my right ear.
All right, I'll try to speak up, okay?
Okay.
And my last question is, if you are not a U.S. citizen, you could have immigration consequences. Are you a U.S. citizen?
Yes, I am.
All right. So to the charge of domestic violence, how do you plead, sir?
Guilty.
Has anyone promised you anything other than what we put on the record today?
No, Your Honor.
Has anyone threatened you to make you do this, sir?
No.
Okay, so on May 19th, 2023, were you at 909 Maplewood Ave here in Ypsilanti Township, sir?
At that time?
Yes.
No. I was at home at that time. Are you talking about when I attacked my wife?
Yes.
No, I was not at home.
What was the address that you were at when the attack happened?
Don't know the address, but I can tell you the streets.
Okay, what were those?
Lincoln and East Michigan Avenue. There's a gas station. There's a gas station going towards downtown Ypsilanti, and behind me there's what used to be a school.
All right, Miss McDuffie.
And across the street there was a Family Dollar.
All right, 1 second, please, sir. Miss McDuffie. He's indicating it didn't happen at 909 Maplewood.
I never did.
I believe they were walking home, Your Honor.
No, I never went home.
No, but you were walking home when it happened.
I don't understand the question. I'm sorry. I wasn't.
Okay. All right. 1 second, Mr. Frost, please.
I wasn't walking home.
Mr. Frost, please stop talking, okay?
Your Honor, the description in the police report mentions that they were walking down the road. The address that the officers listed was their home address. So I am not, I'm actually not clear if Mr. Frost is representing that that it did not happen in the township, how far away they were from I'm not really sure what the location was that he listed. But that's what we have. It's not on that.
I think he's indicating that they were walking down the road.
He says he wasn't walking home. They were walking down the road, but I don't know how close he was to that location.
We were walking away from Lucas's, and I was trying to convince my wife not to I can't even think straight.
Mr. Frost, where were you walking to? Were you walking
We're
home?
walking toward downtown Ypsilanti.
Okay.
We
I
were on
don't,
the way
I,
toward-
thank you, sir. I cannot say whether this address he's referring to is in Ypsilanti Township or not.
It's in Ypsilanti Township because Ypsilanti proper doesn't start until before you get downtown Ypsilanti.
If I
Okay.
can ask this, Your Honor, Mr. Frost got really specific earlier and he talked about a gas station and some cross streets. If I could ask him to convey that information to his attorney, if we could pass this, I'll look it up, see if it's within our jurisdiction. And if so, we can maybe amend the complaint on the record and proceed. If I can verify it is indeed Ypsilanti Township.
Thank you. I can pass it, Mr. Frost. I don't know if you have a phone or a computer
do.
where you can go and get in bed until we get this resolved, because it's gonna take a minute for us to look this up before I recall the case.
Not at my house.
Okay, well, all right, then I guess you'll have to sit there for a minute until we can figure that
Okay,
part.
I'll be okay. I mean,
Okay, thank you, sir. I will recall it in a moment. I'm gonna pass this matter. The court will call the State of Michigan versus Samuel Hamilton, case number 23S00272 and 17T00647.
Rachel McDuffie for the people.
Paul Barnett on behalf of the township.
Assistant Public Defender Allison Muller here on behalf of Samuel Hamilton on the 17T matter.
Janaj Mood appearing with it on behalf of Mr. Hamilton in the other case. Mr. Hamilton, can you please state your name for the record?
Samuel Hamilton.
Thank you. All right. All right, we're here for sentencing today.
Yes, Your Honor.
Case number 23S00272 and show cause as to the 17T00647. I believe we adjourned this to see if there was going to be a victim impact statement.
That's correct, Your Honor. I don't believe we have one.
All right. Anything from you on behalf of your client, Mr. Moon?
Your Honor, as Your Honor is aware, Mr. Hamilton was involved in a car accident that's left him paralyzed with very limited use of portions of one side of his body, specifically only as to his arm and his pinky finger, and he's unable to work. So I'm asking that the court consider ordering just fines and costs, as was discussed previously, with only the statutory or mandatory fines and costs and minimums.
Thank you. Anything from you, Mr. Hamilton, before I impose sentence?
Oh, man.
All right. As to case number 23S00272, fines and costs of $125. State victim impact and the state minimum fee. As to 17T00647, Ms. Mueller, is there anything you want to say with respect to that one?
Your Honor, I did not get a chance to speak to Mr. Hamilton, unfortunately, but I think I would second what Ms. Hamoud said. And if there's any amount, I believe there's 1,200 outstanding on that case. If there's any part of that that could be waived from the court, then I would just ask for the court's leniency given Mr. Hamilton's current situation.
All right, I'll reduce that to the to $200 on that case.
Thank you, Your Honor.
Do you know if he'll be making enough money to do a $25 per month payment plan, Ms. Mood?
Mr. Hamilton, is that something you can do?
Yes, that's fine.
$25 per month on the 15th. And I'll see him back here on June 7th. Nope. One moment, please.
Mr. Hamilton, make sure that you get that taken care of, because once you do, then the case will be dismissed.
Yes, ma'am.
All right, we'll see you back here on June 24th, 2024 at 10 a.m. to see if you're making your payments, Mr. Hamilton, okay? If you're making those $25 per month payments, you don't need to be here. Did he leave?
I know he might have thought that when I told him to make sure that he makes his payments, that was the conclusion of the hearing. Sorry about that.
That's okay. And can you just let him know when the next court dates are, please?
Yes, I will.
All right. Thank you, Ms. Hamilton.
Thank you. Have a great day.
State of Michigan versus Stephen Moss, case number 24S00083.
Rich McDuffie for the people.
Sorry about that. Assistant Public Defender Sandra White on behalf of Stephen Moss. Moss?
Yes, I'm here.
Please state your name, sir.
Stephen Moss.
Thank you. We're here for a pretrial today.
Yes, Your Honor. Mr. Moss that wants to set this for a final settlement conference. I did speak with him that if there is an offer from the people, that he would be rejecting it and that offer would not be held open. I do ask that Ms. McDuffie put any offer on the record.
I don't have once. Am I muted? I'm not muted. I don't have any offers yet, but I haven't completed reviewing the file, so I can't say if there would have been any. So this one is brand new. It's our first pretrial, so I need to ensure that all the discovery is in and everything.
So, Mr. Moss, you do understand that we could adjourn so that the people could find out if there is an offer, or do you still want to set this for a final settlement conference?
Yes, I'll go with the first one.
You want to adjourn and get a new hearing date, or do you want to set it for a final settlement conference?
Yes, adjourn.
You want a new hearing date now?
Yes.
Okay.
All right, we'll adjourn this to April the 1st or April 8th. Which one would you prefer, Mr. Moss? April 8th? April 8th, 2024 at 9 a.m. Bond will continue. We'll see you all then. Have a good day.
Thank you, Your Honor.
State of Michigan versus Paris Callaway, case number 22S00145.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Paris Callaway.
Paris Callaway, please unmute your device and state your name. All right, I think they are gone. Oh, Paris Callaway, please unmute your device.
Hi. Good morning.
Good morning. Please turn on your screen and state
Hello,
your
can
name.
you hear me?
Yes, please turn on your screen and state your name. Can you please state your name?
Paris Callaway.
Thank you. And I can't see your face. There we go. Thank you.
Sorry, my Wi-Fi.
Oh, all right, we're gonna turn your screen off.
Sorry
So
about that, Paris Callaway.
that's okay. I'm gonna turn your screen off here. Stop your video. All right. All right.
Okay. Can you hear me better?
I can hear you fine, but you're fine. All right, go ahead, Miss White.
Mr. Callaway would like to set up a payment plan of $50 a month on the 18th of every month. He plans to make a $50 payment today. And we also like to confirm his current balance due. I should say, what is his balance due? I can't say confirm because I couldn't figure it out last night.
Thank you. You said $50 per month on the 15th of each month?
18th.
18th. You're fine.
And I was because it was originally Ted had said it was going to be 800 because I had Ted for probation. Then I guess it switched to someone else. So how much will it be like altogether?
We're looking that up right now, sir.
Okay.
I did explain that there are late fees, and I thought I saw something about $1,100. That's why we want to confirm.
Yeah. 1,110 is the amount.
Okay. And there's no way it could be lowered?
Trying to figure out how we got there. 1 second, please, sir.
Okay.
All right, so it was never 800, so I'm not sure where that number ever came from. the original amount of fines and costs was $525. And then there was
Okay.
probation oversight fees of $540. So that takes us to $1,065 right there. Then there was clearance fees that are due to the Secretary of State for a total of $45. And
Okay. Is that the reinstatement fee?
well, it's not the same as a reinstatement fee, but it's what allows you to go and pay the reinstatement fee to the Secretary of State to get your license. So it gives you your chance to get your license back. So it was
Gotcha.
never 800 and something, but that is the total, the 1110. I'll tell you what, you make payments, you come back, we can talk more about it, okay?
You said what?
You make some payments on these fines and costs and we can talk more about a potential.
Okay, yeah, I told her that I was prepared to do 50 a month.
Okay. So after you've made some payments, then we can talk about whether or not I can reduce some of those fines and costs. But I need to see some consistent payments first. Okay?
Okay, no problem.
Thank you.
Okay, so do I need to come back or just
Yes.
keep paying?
That's a good point. I'm glad you asked. You should return here for a review if you aren't making your payments, or I'm not really going to consider that the 3-month period. I consider that the 6-month period. So if you want to skip if you're making your payments on time and you want to skip the June 24th date, that's your next court date, June 24th, 2024 at 10. If you are making your payments, you don't have to show up on that particular date, is what I'm trying to say. But then I'll give you another date, which will be 3 months out from that. And then if you want to show up then and talk to me about a reduction, you can't, but you need to show me you're making those payments, okay?
All right, so if I'm making the payments, I don't need to come in June, but if I'm still paying it 3 months out after that, just come back and
we can talk about a reduction. Okay.
All right, thanks so much.
Have a good day.
Thank you, Robert.
We'll call the matters of Quadric Gilliam, case numbers 22W004736B, 20S36615555, and 19S3607.
Personally, Deputy for the people.
Paul Barnett on behalf of the township.
Assistant Public Defender Sandra White on behalf of Quadric Gilliam.
Mr. Gilliam, please state your name.
Quadric Gilliam.
All right. And then it's supposed to be making $50 per month in terms of his payments. Has he been paying? That's why.
No, he did make I should say he made a recent payment of $25 on the 15th of this month. I have his balance to be around about $872, if I'm correct. He would like his payments. I saw that smile. You know I'm trying.
Yes, you are.
He would like his payments to be lowered to $25 a month, and he would like to keep that on the 14th of each month.
All right.
We would like to confirm if I have the 872 correct.
All right, one moment. We'll look into that. While I do that, I'll make the payments on the $25 on the 14th of each month. Your return date will be June 24th, 2024 at 10 o'clock a.m. So the amount is $872.
I'm sorry.
There you go. Better.
What time is that court? What time is that court date, Your Honor?
10 o'clock.
10 o'clock. Okay, thank you.
And you don't have to be here if you're making your payments. Okay. You only have to be if you're not, and explain why you're not. Okay.
Okay, thank you, Your Honor.
Welcome. Take care.
You too.
State of Michigan versus Kenneth Weisel, case number, it might be CISO. I can't remember. Case number 21S00390.
Rachel McDuffie for people.
Assistant Public Defender Donavue Lieb on behalf of Mr. Weisel. Mr. Weisel, could you state your name, please?
You have to unmute, sir.
There we go. How about that? Kenneth Allen Weisel.
Thank you, Mr. Weisel. All right. Mr. Weisel, I need to arraign you on a probation violation today. The probation violation, which is an amended violation, indicates that you violate the no contact condition of probation on October 1st, 2023. That's with Washington County Sheriff's Report number 2379941, and that you had a BAC of 0.186. You failed to notify the probation agent of police contact on October the 1st of 2023, and you tested positive for ETG on March 11th, 2024. You have a right to have a hearing in these matters, at which time, if it is found that you violated the terms of your probation, then you could be subjected to the original maximum penalties in this case. Mr. Lebo, have you had a chance to talk to your client about these violations, allegations?
I have, Your Honor. Mr. Weisel is prepared to plead to the drinking event in October, as well as failing to report the police contact. With regard to the more recent ETG, he has told me that he has sent that out for a confirmation test and is not prepared to enter a plea as to that at this time.
And what about this police report? What is the status of that? Do we know, Ms. McDuffie?
One moment, Your Honor.
Thank you.
It looks like we just got the warrant request in on March 7th. And I see that some media just arrived at our office today, this morning. I'm just waiting for the form to come up because that will tell me if that means that somebody has already authorized it or somebody was requesting that for further information to be able to authorize it.
Thank you.
Looks like it has been authorized as of 8:43 this morning. So those charges will be forthcoming. It looks like it is an OWI third offense notice, so that would be a felony.
Thank you. All right, we're not going to take a plea on those particular parts of the case without having this felony addressed. I can tell you that I am very, very, very concerned about the allegations as they are outlined here in our report. Ms. McDuffie, you have thoughts on bond?
Your Honor, I understand that he sent one of those ETGs for confirmation, but I don't think that that really changes where we are, especially given this new report. I understand that he's not going to want to admit to any allegations for a pending felony case that's coming that he hasn't been arraigned on yet. But one, I would suggest ETG is not going to be sufficient for his testing, given all that. So I will request that the court order him onto SCRAMP, maybe SoberLink, actually, so that we can get those results a little bit faster. In the interim, in terms of, I'm not asking for him to be incarcerated, but I think that Mr. Weisel, whether he believes he has an issue or not, needs to be engaging in some sort of assessment and possibly treatment at this point.
Thank you. Mr. Lee?
Your Honor, I have no objection to either of those proposals.
All right, what I'm going to do is you need to be placed on the SoberLink device, sir.
What's that?
Your attorney can explain it all to you. You blow into the device so that they can monitor your alcohol drinking and that will be twice a day.
Okay.
And then you need to complete a new substance abuse evaluation, and we'll bring you back here.
Okay. So so now there's a warrant out for me for the October 1st charge.
The warrants are not out yet. It literally just got authorized this morning, a couple hours ago. So it's gonna take some time for that to go through the system and for a warrant to actually issue.
Okay, so how long, when should I take care of that? That way I'm not accident.
Mr.
That way I'm not
Lebo,
driving and get pulled over.
Mr. Lebo, do you want me to put you in a breakout room so you can talk to your client about his next steps?
Just briefly, Your Honor. Thank you.
That's what we'll do. And sir, we'll see you back here in this court on April the 15th at 10 o'clock a.m. Okay?
Thank you, Your Honor.
To community corrections anytime after 11 o'clock for his sober link.
right.
Say again.
You need to report to community corrections today after 11 o'clock to pick up your sober link.
I'm in the middle of teaching classes. They're how late are they open to?
4:30.
What time?
4:30 p.m.
Are they open early? Like at what time are they open?
Your Honor, could Mr. Weissel get 24 hours to pick up his sober link?
What I'm asking is just I'm in the middle of teaching class and I'm in a bind here. I mean, I'll do what I'm told.
Any thoughts on that from the prosecution or probation?
I'm just not sure how early he's trying to go and if they're open as early as he is intending to show up there.
I'm not going to get into all those details. I will give him 24 hours and he needs to work that out.
Okay. That'd be helpful, Your Honor.
All right. 24 hours. Sir.
Thank you, Your Honor.
Are we ready yet on the Frost matter?
Ms. White?
Did you get them from? She's in the breakout room. Okay, so I guess we're not ready. Did you get the information you need, Ms. McDuffie?
Not yet, Your Honor. Your Honor, I'm going to do this. I'm just going to go back and pull up the live stream myself with my audio off on here so I can hear what he said, and I'll just get it that way.
I think it was Lincoln and hold on one second. Lincoln and
East Michigan Ave.
Lincoln and East Michigan Ave.
Thank you.
Thank you. We got it. Thank you. State of Michigan versus Cordell Nelson, case number 21 S392626 A and B.
Rachel McDuffie for the people.
Oh, I'm sorry. And it's not A and B. It is 20W004640B.
Paul Barnett on behalf of the township.
Thank you. Ms. Moeller, could you substitute in for Ms. White if this is her matter or Mr. Lebo's? They're both in breakout room.
Your Honor, I apologize. I'm sorry, Your Honor.
This is Cordell Nelson.
Assistant Public Defender Allison Miller here on behalf of Cordell Nelson. Mr. Nelson, did you state your name for the record already?
Cordell Nelson.
Thank you. All right, Mr. Nelson is here for payment. He's supposed to be making $50 per month on the 24th of each. On the 24th of each month. Can you tell me what he's making his payments from? And then I'll just wait till you come back. This payment too. It looks like he's not making payments. Mr. Nelson, why are you not making your payments,
I
sir?
made the full payment. I paid the whole thing off.
Which
I paid
one?
the whole the 290.
Oh, so it must be a ticket that's not on today that you paid off. And so therefore it doesn't show up. Okay.
I'm sorry.
So when the ticket gets paid off, it doesn't get on the docket. And so therefore we have to look somewhere else to see whether or not you've been making payments because that's no longer on the docket.
Okay.
The A ticket, the 20. Oh, the A ticket of this was paid off. All right, so he did make payments. All right, so we'll see you back here, sir, on June 24th. Okay. Thank you,
Okay.
Mr. Nelson.
I got a question.
Yes, sir.
Is my license on hold?
I don't have info on your license today. Let me see something. One moment.
Ain't got no info.
It's not on hold. It just shows it's not valid. You just need to go to the Secretary of State and get your license, sir.
Okay.
So just go over there and they should give you what you need to get reinstated. Okay?
Okay.
All right. Thank you, sir. Have a good day. State of Michigan versus MIWashington, case number 23 FB 1034.
Rachel McDuffie for the people.
Assistant Public Defender.
Sorry.
Nope. Is that on mine or yours?
It is. I didn't know you were back. I'm sorry. Go ahead.
Thank you. Assistant Public Defender Sandra White on behalf of Nicholas MIWashington.
Thank you. Mr. MIWashington. Go ahead and state your name, sir, please.
Nicholas MIWashington.
Thank you. Good morning, Mr. MIWashington. So it looks like the defendant is now, Mr. MIWashington is now engaged with the ABR program. He's completed 16 of the sessions. How are those sessions going for you, Mr. MIWashington?
They're going well. I mean, I don't say that I can't say that I like it, but I like that class. It's not we just had like, I don't know, maybe like 4 new members last Tuesday, and it's funny that their faces are always like, oh, here we go with this, and I'm like, it's not as bad as you think, and it turns out it's usually not. So,
well, good. I'm glad that
the classes are. I enjoy the what's her name? The instructor. She's really nice. I don't enjoy paying for it, but I guess I don't get no choice. I'm homesick from work today. That's why I don't feel good.
Oh, you don't feel good. But you're getting something out of the class?
Yeah. I think that the material is like a little bit outdated. It's from like the 90s. So it's like it's a lot of the stuff that they're talking about, or at least some of it, like is more advanced or it's just different now. It's not like exactly like it used to be. It's early 90s, so it's just tough sometimes. But overall, it's still the same issues, really.
Okay. So are you saying that because the book you are reading is dated from 1990?
No, I'm saying that like because they talk about some stuff like let me turn this fan off. They talk about like just some of the topic, like a man, like they talk about the man box sometimes and everything that they pertain to it it's like none of that stuff is okay now. Everyone knows it.
Oh, so it's not politically correct, is what you're saying?
Well, I'm not saying that it's not, no, not politically correct, but I think that it's just, I think that the right and like different stuff that's happened since even the 90s. Not the rights hasn't changed, but just I don't know how to really explain it. The culture. The culture has changed since the
The
90s.
culture, I see. Gotcha. It's interesting. I'll have to look into that. Thank you for sharing.
Thank you.
All right, I will. You need to start making some payments, but I hear you saying you have some financial challenges. So it looks like we're going to do a review in 90 days. And if you are where you need to be, then you can be discharged. Okay.
Okay.
All right. So we'll see you back here on June 24th at 10 o'clock a.m. And if you've completed everything, then Miss Johnson can discharge you if she so chooses. Okay.
Okay.
All right. Thank you, Mr. MIWashington.
All right. Thank you, ma'am.
State of Michigan versus Gerard Calhoun, case number 23 FB 1153.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Gerard Calhoun.
Mr. Calhoun, please state your name.
First name Gerard, last name Calhoun.
Thank you, sir.
You're welcome.
All right, we're here for sentencing today.
Yes, ma'am.
Have you had an opportunity to go over the report with your client?
I have, Your Honor, and there is no any deletions, corrections, or additions. I would like to address the recommendation when the court is ready.
All right. Ms. McDuffie?
There may be a couple of updates in a sense to the recommendation, which are
that is true. I'm sorry.
Well, not to the recommendation so much, but to the report. So the last time we were here, Mr. Calhoun was in custody. He is obviously not in custody at this time. So he is released on a tether for his Third Circuit case, which he was sentenced to probation on pretty recently. I think it was within the last few weeks. Mr. Calhoun also has, which I suppose would be a potential violation of bond for this case. He has a pending R&O felony out of Southgate. Currently, it's in the PCC stage. His next date for that case is March 22nd. He was just arraigned on that on March 7th. So that's another one coming up for him, which would also be out of Wayne County. And his tether is covering both of those cases out of Wayne County as well. In our case, the recommendation was originally a jail recommendation because it looked as if he was going to be in custody. And of course, we had discussed him getting a mental health assessment somehow, somewhere, so in custody if needed. My only request, I don't know which direction his sentence is going to go in, given that he is released from Wayne County but also has a new case. I just want him to get that assessment and so that we can determine what is going on with Mr. Calhoun so we understand what's necessary to recommend further, if anything.
I think we should do a breakout room on this one.
Okay.
Mm-hmm. All right, we're back on the record in the case of the state of Michigan versus Gerard Calhoun. Mr. Calhoun,
Yes, ma'am.
at this time, sir, I think that we are a little ahead of where we need to be in your matter, and we need to have the assessment done, the mental health assessment, before I can come to
Yes,
a conclusion of what should happen in this case. So
yes, ma'am.
adjourn it to give you time to get that done, okay?
Yes, ma'am.
All right.
Ms. Washington, can I say something?
That's up to your attorney.
Okay.
Ms. White, are you okay?
Mr. Calhoun, let's not say anything until you and I speak, okay?
Yes, ma'am.
All right, we're gonna adjourn this matter to April the 5th. Did I say the 15th?
Yeah.
To April 15th at 10 o'clock a.m.
Yes,
Sir,
ma'am.
make sure you have that assessment done before then, okay?
Yes, ma'am.
Your bond is continued.
Yes, ma'am.
Thank you, sir. Have a good day.
You said April 15th?
April 15th, tax day, sir.
Okay. Thank you, Ms. Washington. You
Thank
have
you.
a good
It's Washington, not
I mean,
Washington.
you have a good one.
Thank you, you too. All right. Bye-bye. All right, the court will recall the case of the state of Michigan versus Victor Frost, case number 23-00355.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Victor Frost.
Mr. Frost, if you could unmute and state your name again, please, sir.
Victor Harold Frost.
Thank you. All right, Ms. McDuffie, did you have a chance to look up those addresses?
I did, Your Honor, and I was also able to thank you to the court for getting that information, and I was able to actually listen to a little bit of the live stream too. I do see that on East Michigan Avenue and Lincoln Street, just like he said, there is a Family Dollar, there is a gas station, and there is a former school, exactly as Mr. Frost described, and this is in Ypsilanti Township in this area. So I don't think we have a problem with jurisdiction.
All right, thank you so much. All right, now that we cleared up the jurisdictional issue, Mr. Frost, first of all, you're still under oath, okay, sir?
Yes, ma'am. Yes, miss.
All right, do you acknowledge that at that time and place that you indicated earlier, you assaulted and or battered a Miss Julie Frost?
Yes, I do.
And what did you do to Miss Frost?
I hit her with an umbrella.
All right, and she didn't give you permission to do that, right?
Oh, she didn't.
And that was your wife?
That was my wife.
All right, I find that there's a factual basis for the plea has been willingly and knowingly made. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
Satisfied.
All right. Sentencing in this case will be on April the 15th, 2024 at 10 o'clock a.m., sir. Did you write down the phone number earlier when I gave it out for you?
My friend did.
All right, good. Thank you.
It's what's this appearance that I'm supposed to have, or a phone call, or what?
Yeah, you need to call them tomorrow after 9 o'clock and they'll schedule an appointment with you.
Who am I supposed to call?
The probation department.
Okay. I just want to make that clear. I thought that's why, but I have to make that clear. Thank you very much.
And call them after 9 o'clock tomorrow and they'll schedule a time for your next appointment with them. And then you come back here for sentencing, okay?
For what?
For sentencing.
Remember we discussed this? Give me a call and we'll discuss this again, okay?
Your name is?
Sandra White.
Oh, I have your phone. Okay, when do you want me to call you?
I'll give you a call this afternoon.
Okay.
All right. Thank you, Mr. Frost. All right. I believe that at this point, we are going to get prepared for our in-person hearing. I'm sorry. Yes. And so we'll be on a brief recess for about 5 minutes.
Hi, is court still going or are we on mute?
Court is still going and you need to remain muted, please, until your matter is called. Thank you.
I was just making sure my microphone worked. Thank you.
All rise. 14B District Court is in session. MIWashington presiding.
Thank you. You may be seated. We'll call the case of the state of Michigan versus Michael Hensman, case number 23S00207.
Rachel McDuffie for the people.
Good morning, Your Honor. Robin McCoy on behalf of Mr. Michael Hensman, who is sitting to my left.
Please stand and state your name, sir.
Michael Hensman.
Thank you. All right, we're here for sentencing today. Have you had an opportunity to review the pre-sentence investigation report with your client?
Yes, I did, Your Honor. There were really no additions, corrections, or deletions. I would just note for well, my client has indicated for the drug and alcohol screening that's not been a big issue. That was not raised as an issue in the case. So we're asking that he, I know there's a recommendation that continue. We're asking that be discontinued. He said for the creatine that he was taking that with, I guess, health issues, but if the court, you know, I don't know, I guess we have to see what the court, he said if the court has a problem with that, he would stop taking that.
All right, thank you.
And then we also did want to inquire about, he wants to have an appeals attorney appointed. He said he's indigent and can't afford one.
So he has to fill out the proper paperwork for that.
Okay.
All right, Ms. McDuffie.
Your Honor, as far as the recommendation goes, I agree with it. I don't have any issues there. What I'm disturbed about is just everything that's in it with respect to, in this trial, we did have a jury trial on this case, and Mr. Hensman was convicted of one count of aggravated domestic violence as charged. And while he apologizes for making a mockery of the court and having it appear like a Jerry Springer episode, I talked about a reality show quite a few times, given some of the nature of the things that came up in this case. I don't know that his apology even refers to himself, because it appeared to me as if every opportunity was taken by him in that trial to embarrass and humiliate this victim. And this is one of the most disturbing, not only the reports with the defendant's account, but the sentencing statement in this case is just unbelievable to me, that opportunity was taken to basically submit a new case against this victim. And to see that these statements were allowed in, obviously over my objection in court, but there was this opportunistic thing about making her out to be some sort of alcoholic, some drunk who was constantly, and now that he's cautioning his kids on what to do in case she hurts them. I am truly outdone and disturbed by the behavior that I saw during the trial, and that is continuing afterward in this case. This is not just about the physical harm that was caused to Ms. Lucas. Aggravated assault means there's an injury. She had a ruptured eardrum from being struck by Mr. Hensman in this case. But the pulling a gun to your own head and threatening suicide is a part of the control and manipulation that goes with domestic violence. this rationale, I think in this report is one of the first time I've ever seen this version of explanation, which is that he did it to get her to move her car. I don't know where to even begin about how effective any sort of programming or intervention, or he's supposed to be in some counseling on his own right now, according to, I believe, his attorney, but I don't know what it's going to take to even begin to get through to Mr. Hinsman, because not just a reality show, but this alternate reality that seems to be the case. Of course, I'm not home with these people every day. I don't know what goes on in their homes, aside from what we learned about in this case. And clearly there's two very different versions of what happened here. But all of the accounts that were presented by the defendant are completely unrealistic. They're contradictory. They're inflammatory. They're disturbing, like I said. And we've seen enough of what we can be assured really happened because he admitted to some of those things. He just changed his rationale for why he did them. So I'm so concerned, but I don't want to go on and on because we also have a victim impact statement from Ms. Lucas in this case. Ms. Wilson is present to read that on her behalf today.
Thank you, Ms. Wilson. You may proceed.
Thank you, Judge. I've been asked to read into the record a victim impact statement authored by Leslie Lucas. Hello, my name is Leslie Lucas. On February 25th, 2023, I was struck in the face and verbally attacked by Michael Hinsman at my home with our children in the house. He hit the left side of my face so hard that he ruptured my eardrum. I could not hear anything in my left ear. It was painful and took weeks to heal and fully gain my hearing back. My boys and I's lives have changed drastically since this happened. The boys didn't know what happened at the time, but weren't surprised when Michael didn't stop over anymore. They didn't like going to his house. Michael was verbally abusive and mean towards them sometimes. I wondered about my safety, so I obtained a PPO for myself. How do you explain something like this to your children? I was trying to keep things amicable when I ended the relationship mid-February of 2023, allowing Michael to come over and visit with the boys or pick them up from my house when I was working. All of this could have been avoided if Michael respected my decision to end the physical relationship that we had, instead of still trying to control my every move. Michael, you need to take responsibility for your actions and prove to the boys that you can be a good person after all of this. They need a father in their lives that will treat them respectfully and not degrade them. They need a positive role model. They are boys and they should look up to their father. When a person says that a relationship is over, it doesn't give him or any person the right to still want to think they have control over any person's every move or any part of their life, regardless if you have children together or not. No person deserves to be treated like Michael treated me. I'm the mother of our children. Jealousy is a terrible thing for impressionable children to view. It devalues the family structure. I've struggled to get my sons to show me respect. They are going through a tough stage of puberty in their lives right now. They need a father that can explain what is happening to their bodies and minds. I will try to help them, but I am mom, and they get embarrassed. I've never intentionally kept the boys from seeing Michael. If anything, I did everything not to break the relationship that the boys had with him and his family. Anytime they have significant contact with Michael and his family, I spend the majority of the week following asking and trying to make them respect our household. Everything that I do is for the betterment and development of our children. And through all of this, I hope he understands that the he and I part of this is done. But I need for him to understand that the he and our children part is ongoing. The development of our children is his responsibility as well, and I hope he takes it seriously. My takeaway for Michael would be for him to receive help with his anger issues and his depression. Our boys deserve to have a kind, caring father that will be there for them. I, however, do not want to be around Michael at all, nor do I want him to come near my home, my safe place. I would like for this court to make sure he relinquishes any harmful entities or devices that could cause me or our children harm. My statement to Michael: I hope that this incident has shown you that you need to treat people with respect and to cherish every moment of every day that you can spend with our children. Also, may anyone that you come in contact with be treated with respect and kindness. I never wanted our relationship to end like this, but Michael, you scared me in a way I never thought was possible. I wish the best for you. I want you to show our boys how to be a decent person. Thank you, Judge.
Thank you very much. Thank you. Ms. Lucas. Ms. McDuffie, anything further from you?
Your Honor, nothing further from the people, Your Honor. It's just really, it's really sad to see that Mr. Hinsman has turned himself into the victim. And I hope that that itself turns around and that he starts to open his eyes to what's happening here, what needs to happen.
Thank you. Ms. McCoy, anything else before I go to your client?
Yes, I would just note for the record that my client has no prior record. This was an isolated situation. He has been taking therapy, so he has been doing therapy from the beginning and trying to address these issues. You know, as Leslie said, they still have kids to raise. He said he is very apprehensive about being around Leslie while the personal protection order is in place. It's my understanding through the friend of the court that they've set it up for there to be visitation at the mall. But he said he's still, where she drops off the kids and he's there at the mall with the kids for 6 hours. But he said he's just concerned. And he says he has no desire to be around Leslie at all in this matter.
Ms. Lucas, you mean? Calling her Leslie.
Oh, I'm sorry, Miss Lucas. Yes, he says he has no desire to be around her. And then let's see. There's a family friend, Mary Hawk, who's here, who said she wanted to briefly talk to the court on Michael's behalf.
We don't do that here.
Okay.
If she wants to submit a letter, she could feel free to do that.
Okay. All right. I have nothing further, Your Honor.
Mr. Hinsman? This is your opportunity to say whatever you would like to say to the court at this point. I did review your statement. I found it to be very interesting as well, along with the prosecutor. What would you like to say, sir? Please stand.
There is nothing I would like to say, Your Honor.
Thank you. You can have a seat, sir. I agree with the prosecution that it is extremely rare in my career, 30 years, that I see such a divergent concept of what happened in a situation. I'm struggling with what to do about this case. Because one of the problems of going to trial is not only does the jury get to hear what happened, but so does the court. I'm very concerned that there is some concept that there's no mental health that has been part of this case. When people pull weapons on themselves, that's a huge issue. Not only that, but the defendant got up himself and testified about all the trauma and damage he suffered at the hands of his own mother. So mental health is certainly an issue in this case. think what I'm gonna do is follow a recommendation and see how this goes. Is the sentence of this court that you serve 365 days in the Washington County Jail, credit for 1 day. 364 days are suspended. You're on probation for 24 months. Fines and court costs in this case for a total of $625. View the probation when and where directed, including any and all home visits. Attend and complete the Accountable Choices Battery Intervention Program at a rate of 1 session per week for a minimum of 52 sessions, including the weekend program. Must remain compliant with all of their attendance policies to be considered compliant with probation. You're to attend and complete a mental health assessment. You're restricted from having alcoholic beverages in the home. Submit to, pay, and be responsible for random drug and alcohol tests as requested by the court, any probation or police officer or treatment provider for a minimum of 1 time per month. You're to provide monthly verification of compliance of all of your probation conditions to the probation department via their online reporting platform. So you must report online once a month. You're to attend court reviews as ordered and make earnest efforts to maintain legitimate employment. The child exchange shall continue as stated and directed by the friend of the court and to take place at whatever entity they believe, whether that's the law enforcement or Briarwood Mall or wherever that is. We'll follow that recommendation. You refrain from harassing, stalking, threatening, or engaging in any conduct that would place Leslie Lucas in reasonable fear of bodily injury. No assaultive or threatening behavior towards her or anyone else. No contact with her except for the child exchange if it is necessary. And I don't think it's really necessary for you to have any contact, but there may be some incidental contact. No going to her place of residence or place of employment. No use of possession of alcohol, marijuana, illegal drug paraphernalia, and no being in the presence of anyone using those or any firearm components, ammunition, or other dangerous weapons. Do you understand the last part, sir? If you have a firearm, you need to turn that over to the police department.
I don't have any firearms.
A review in this case will occur in 45 days to make sure you're doing what you're supposed to be doing. That's going to be on April the 29th. I'm sorry, 1 moment. That's going to be on May 13th, sorry, at 10 a.m. Are you available then?
May 13th, okay, will that be on Zoom?
Yes, it'll be on Zoom.
Okay, and you said at 10?
Yes. You have any questions about your sentence, sir?
No, you're on.
Mr. Hensman, I hope that you take this seriously and follow the recommendations. And if not, then when you come back, you're not looking at a continued probation. You understand that, sir?
Would you like me to stand, Your Honor?
No, but do you understand?
Yes, I do understand, but yes.
I'll see you back on Zoom on May 13th, sir. And make sure you reach out to the probation department so you can sign your probation contract. Okay, all right, thank you.
And Your Honor, will they have the appeal paperwork at the front, the clerk's office?
I believe that we have it here, actually. I mean,
I'm used to what, you know.
Yeah, I know, everything's changed. 1 second, let me see if it's here. We haven't had to use one in so long. Yes, Ms. McCoy, go out to the desk and see if they have it out there. If they don't have it out there, they'll let me know and we'll figure it out.
Okay, thank you, Your Honor.
All right, thank
Hope
you.
you and your staff have a great day.
Thank you, you too. All right, the court will call the matter of matters of Bryant Murphy, 22S 402722A and B.
Rachel McDuffie for the people.
Assistant Public Defender Johnson Reed on behalf of Mr. Murphy.
Good morning, Ms. Washington. Good morning,
Good
Ms.
morning,
Washington.
Mr. Murphy. How are you, sir?
Okay.
All right, we're here for a review of his payment plan. He's supposed to be making $50 per month on the 15th of each month.
That is correct, Your Honor. I discussed matters with Mr. Murphy. Mr. Murphy is asking for a 30-day adjournment of this review. He is currently out of work. He's currently looking for work. He's also supporting multiple children and tells me he's experiencing homelessness at the moment. So he would like an adjourned review date so that he can continue his payment plan once he's in a financially stable position.
May 13th, 2024 at 10.
Thank you, Your Honor.
So better for you by then, sir, okay?
Thank you, Ms. Washington.
All right, see you then, Mr. Murphy.
All right.
Bye-bye. All right, the court will call the Tolbert Smith matters. Those are ticket numbers 23W002350. Let's see here. A, B, and C, as well as 21W001603A and B.
Paul Barnett on behalf of the township.
Assistant Public Defender Sandra White on behalf of Tolbert Smith.
All right, Mr. Smith is in custody at the Washington County Jail, but he has been refusing to come out for his pretrial. I think this is around the 5th time he's refused to come, and the court felt it was necessary to make a record of that because otherwise it looks like maybe he's sitting there and we're not doing what we're supposed to be doing. We've gotten emails and have the documentation from the jail of his refusal each time. Ms. White, is there anything you would like to say?
He has also refused to see counsel also, Your Honor. I do know that in his felony matters, they are filing for competency. Need to see if I can also file. The last time I looked into this, I had to speak to him first before I could file. I don't know if Your Honor has any information on that.
Well, the reality is, given the number of times that he's refused to appear in court, it does appear that there are some concerns about him understanding what's in his best interest and not in his best interest. So there is, and if he's been referred on another case, I don't know if you need to speak with him. Given there's another referral.
Okay, I will file a referral in this matter. These matters.
If it was filed already today, I would just move it out. But given that we don't have the referrals yet, I will move it to March 25th and see where we are with those. I think it can only be in the pretrial cases. Some of these are show causes, so please file it in those.
Okay.
So March 24th, 2024 at 9 a.m. At which time if they're filed? March 25th. Yes, March 25th, not 24th. We don't want to be here on Sunday. At which time if they are filed, then I will adjourn them out till we get some response from the forensic center. For the documentation. Yes. There is an option. For State of Michigan versus Naomi Blackman, case number 21S00038.
Rachel McDuffie for the people.
Apologize, Your Honor. Assistant Public Defender Allison Mueller here on behalf of Naomi Blackman.
Defendant has failed to appear today. Apparently she was, or he was arraigned on March 4th before the magistrate and given another opportunity to show today. There has been a bond violation report filed also for failing to appear and test or do anything that was ordered there as well. At this point, it looks like the defendant just is not going to follow the court's order. Bench wanted to issue.
Your Honor, I just wanted to also bring to the court's attention, there's an additional bond violation. In the one, Ms. Blackman had been arraigned back in about a year ago and failed to report for testing at that time. And so this is her second cycle of failing to test. Additionally, we had a warrant request for aggravated stalking for a violation in this incident. That was denied, but I'm going to revisit that issue because I think I see something in that report that may have been overlooked. So alcohol is a very big factor. Obviously, she's not here, but I just want, when the court is issuing the warrant, I just wanted to make the court aware of all of those circumstances because that's still a violation whether or not that warrant is ever authorized for contact.
Yeah.
And Your Honor, I didn't have any successful contact with Miss Blackman. I reached out email and via calling her and wasn't able to be in contact with Miss Blackman.
$25,000 cash assurance. State of Michigan versus Glenn Milhan, case number 23 FB 1548.
My apologies.
For the people.
Assistant Public Defender Dobby, leave me off Mr. Milhan. Your Honor, I believe this was scheduled as an in-person and Mr. Milhan is present.
Yes. What?
He is out.
We were told that we have no one else. Let's check in the halls. Did he just show up here?
He did. What he told me is that he had went to 15th by mistake and then discovered that he was supposed to be at 14B, got on the bus, and he is now present.
Nobody here? He could be at the wrong port.
Yes. Mr. Lebo, there is no one here in our building, sir.
I just spoke to him in person in my office a moment ago. I will go check the area outside my office, Your Honor.
Okay.
I checked the hallways and the bathroom and nobody here.
We'll let him look for his client.
Okay.
I have found him, Your Honor, and we are on our way to the courtroom.
He was waiting in the hallway from the public defender's office. That's why.
Well, we'll call the matter, or I guess we already called it, but I'll recall it since you're in here. The State of Michigan versus Glenn Milhan, case number 23 FD 1548.
Rachel McDuffie for the people.
Assistant Postmaster County Legal on behalf of Mr. Milhan, who's standing to my right. Mr. Milhan, please state your name.
My name is Glenn Warren Milhan.
Thank you. Good morning, sir. You may have a seat. All right, we're here for sentencing today. Have you had a chance to review the pre-sentence investigation report with your client?
Your Honor, my understanding was that the court was requesting that the sentencing be adjourned for a release of information from CMH, which we have obtained at this point.
All right, thank you. And you provided that to, well, does anyone have the information from CMH?
Unfortunately, I believe the release was just signed this morning, Your Honor, and I do have an explanation for that I can provide to the court.
All right, please.
Your Honor, so when I discussed with Mr. Milhan, he frankly told me that he was experiencing some mental health difficulties. He had been off his medication, which he's now back on and is doing quite well on, and that as a result of that, he had neglected to get the release of information signed in a timely manner. It has now been completed and signed. I have a copy of it, which I've seen.
But it has not been shared with probation or anyone yet?
No, it was just signed this morning, Your Honor.
Duffy?
Your Honor, we had a very eventful last attempt at sentencing, which was why the court obviously required, we needed the release of information first, I think is a first step, but the court wanted to actually hear from CMH or to get more information about what's going on before we can proceed with sentencing. I would agree that that is still appropriate. So I would ask that we actually not proceed with sentencing today unless the court has the information that it needs, the court and probation.
I obviously do not have the information I need at this point. All right. Let's go with the April the 15th date.
Thank you, Your Honor.
At 11 a.m. in person again. All right, Mr. Milhan, hopefully we can get the information we need, and hopefully now that I was reminded of how eventful things were last time, I'm hopeful that we don't have those issues in the future.
I understand.
All right. I'll see you back here on April 15th at 11 a.m. Okay, sir?
I apologize for not getting that paperwork to you. They cut my house insurance and stuff off, and I kind of a couple weeks something went without my meds. I don't have that to help me. Going to the DHS office with me and help me get, I kind of got thrown off for a minute because
Got you. That makes sense.
I
All right,
apologize.
thank you, sir.
And I do want to note for the court, when I spoke to Mr. Milhan, he displayed a great deal of insight into his mental health situation.
All right, thank you. That helps a whole lot. Thank you. All right, we'll see you back here. Okay, sir, thank you.
Appreciate it. No problem. Thank you.
All right, that I think completes our docket for today.
Thank you so much. I'll just ask Ms. White, please let me know about that SIP so I can get tomorrow's hearing.